very simple. I have thousands of people that pay their child support and don't come. A lot of the information you provided does not apply to the civil court system. You're using language from the probate court that do not apply. Howard Jr. File number 19-46860DM. Mr. Howard, I'd like you to sit at defense table, Bregman, and whatever witness you might have. Mr. Howard, there is no contract by entering the courtroom. A basic understanding of the law would dictate that there's no contract by having a seat being seated. I know that you're Daryl Howard. I've had jurisdiction.
Right, and
I've had jurisdiction over you before because you had a case for a felony child support case as well as appearing before. So this is the date and time set for hearing in this matter. Mr. Bregman, Katie Howard is in my waiting room. Is she going to be a witness today?
No, is this a show cause for failure to pay?
No, this is a bench trial.
Yeah, show cause bench trial for failure to pay.
Yes.
Yeah, go ahead. I have the further court.
Okay. Any objection to Ms. Howard viewing?
No, she can certainly.
Are you calling Katie Howard as a witness?
yeah, I can.
Okay, so hold on. Ms. Howard, I just wanted to let you know we're here. We're going to start the hearing. Now, if Mr. Howard's calling her as a witness, should I sequester her by putting her in the waiting?
No, it's fine. She can.
Mr. Howard, do you want me to sequester her? She is a party to this, but do you want me to put her in the waiting room until you call her?
Yes.
Okay, so Ms. Howard, I'm going to pop you in the waiting room, all right?
Okay.
This is the date and time for a show cause bench trial in this matter. Mr. Bregman, are you ready to proceed?
I am your.
Mr. Howard, are you ready to proceed? Yes or no?
No, I had one thing I wanted to make sure. The original contract that she signed up for, I wasn't a part of. So is that what happened?
There is no contract in the birth of a child in support of the child. So thank you. Mr. Bregman, are you ready to proceed?
I am your.
All right, may I call your first witness?
Let's call Mr. Basquez.
Mr. Basquez, you want to step up here, please? Mr. Basquez, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, have a seat, please. Can you state your full name for the record, please?
Jay Basquez,
And you are employed by?
front of the court.
All right, very good. Mr. Bregman?
Mr. Basquez, could you say your position with the front of the court?
Enforcement officer.
In that capacity, do you have access to the defendant's files and records?
I do.
Is there an order to pay child support?
Yes, sir.
What does that order state?
Mr. Howard is ordered to pay $151 a month. And he is currently behind the amount of $8,298
That's the arrears as of what date?
today.
And when was the last time you received a payment?
He made a $1 payment on October 26th.
Of this year?
Correct.
And when was the last payment before that?
December of 2021.
And how much was that?
$14.38.
So since December of 2021, he's made a total of about $15 in payments.
Correct.
And how long has this order been in place?
The original order was entered October of 2019, and judgment divorce order that support remains the same. That was March of 2020.
No further questions, Your Honor?
Right, Mr. Howard, do you have any questions for Mr. Basquez?
Yeah. When was the last time you had conversations with Mr. Howard, the defendant? When was the last time you inquired about the ability to pay?
That's not the front of the court's job.
Are you the caseworker for the defendant?
Yes, I am.
So when was the last time you and the defendant spoke to each other?
On this case, I'm not sure. I don't know if we ever have on this case.
Now, originally on this case, the defendant, when you had the order signed, is that the same day that he was taken in incarceration?
I have no knowledge of them.
So October, okay, so let's go to October 1st, 2019, is that correct?
The original order was entered October 28th of 2019.
Okay.
And you were served July of 2018. This order.
So on October the 1st, because he was incarcerated for 4 days. On that day, recollection shows that the defendant
Well,
and
Mr. Howard, can I first inquire, why were you incarcerated?
for a failure for the case, was there for,
The felony child support case?
was there taking care of
Okay, so
this.
he didn't deal with a felony case, so. I don't
Right,
know
but I'm
that-
speaking in, okay, well, in regards to this case, on that same day, 2 officers there, that was the time that this was supposedly signed to be a child support order.
I signed the child support, not you.
Okay, well, during that time period, there seems to be a mistake in fact, okay, all right.
I have no follow-up questions for Mr. Basquez.
Have a seat. Any other witnesses?
I have no further witnesses, Your Honor.
Okay, Mr. Howard, so do you wish to call any witnesses?
Mrs. Howard,
Okay,
stand up.
you can stand at the podium.
All right,
And then she's going to be up there, and I swear in. Ms. Howard, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name for the record, please?
Katie Suzanne Howard.
All right, very good. Mr. Howard?
okay. At the time when you, at the time of conception, were you married?
Of what session of the,
Of the child?
So, Mr. Howard, the only issue we're really here on and we need to focus on is the child support and failure to pay.
Correct, but if the child was born out of wedlock, then we have to figure out a different scenario because all
No,
that's not
doesn't make
true.
a difference if she was married to you, married to
That-
somebody else, or not married at all.
All right, let's see here. Okay, so. Okay. Underneath, Michigan Common Law 700.7901, there's remedies for breach. Violation of trustee owes the trustee to the beneficiary, which is Mr. Howard, is not of the breach to compel the trustee to perform trustee duties and joining trustees committed the breach of the trust. Order trustee to account, appoint a special fiduciary to take possession of the trust property and administer the trust. So with that being said, with my living trust, because this estate,
So you have an estate, a living trust where you're
Is it-
receiving income from?
no, this estate that we are administering right now, Mr.
An
Howard.
estate is a guardian, or is involved in probate court. So does that mean you have an inheritance in an estate?
Okay, well, this is the problem. The person that Mr. Howard that you are referring to is different from the one in the living trust. Living trust, you have receiving beneficiaries that are inside of the living trust. So there's a problem.
Can you define trust for me, Mr. Howard?
Okay, well,
A trust is an inheritance
yes,
or money that's set aside for people to inherit or
yes.
be given. So do you have that money?
My beneficiaries are in the trust. I don't have, inside of my living trust, my beneficiaries, that's the
it's
problem
your
inside of
living
this
trust.
court.
Okay,
My
that
children
doesn't
are in
apply to
here.
this.
My children are inside my living trust.
It doesn't apply to this.
Still, I mean, you can,
It's simply the law, Mr. Howard.
I know, and it's a law that I can invoke the DPP to have parental immunity as well.
There is no such thing as parental immunity.
From the U.S. Department of Civil Rights, 2016, Dear Colleague letter explains things a little bit different.
I'm sorry, what letter?
2016 Dear Colleague letter,
Your colleague letter?
yeah, 8 pages.
Okay,
Okay, thank you. Any other questions for Ms. Howard?
Was there ever an agreement to not have child support?
no, there was not.
You're under oath.
She's answered your question, so. Do you have any other questions for Ms. Howard?
No.
Mr. Bregman, do you have any questions for Ms. Howard?
I have no questions from Ms. Howard.
So,
All right, Ms. Howard, you can go ahead and mute yourself. And, all right, so Mr. Howard, is there, we have closing arguments you can make, or you can make a statement and allow Mr. Bregman to cross-examine you.
A well-known legal principle in courtroom psychology is procedural avoidance. When someone refuses to testify, it can feel safer emotionally, but it also locks the record. Here, declining to testify preserves personal comfort, but it removes the only chance to legally establish inability to pay. Silence doesn't stay neutral. In civil enforcement, it usually strengthens the existing order.
So which would you like to do? Do you wish to testify?
I got 50 minutes, right, where
Do
I'm
you
gonna
wish to testify?
myself. No, but I,
Okay, so do you wish to make a closing statement? Then?
sorry.
So you don't wish to testify today? No? Okay. Mr. Bregman, do you have a closing statement?
We're gonna rely on that testimony, Mr. Basquez.
All right. Mr. Howard, do you have a closing statement?
Personal identification that I want to be redacted. I have a loan form, fiduciary form that I wanted to be done. And I also have a sworn supervised administration of a trust that I want to get taken care of. But as far as the ability to pay, I haven't had in the last 3.5 years. I've had a possible charge. I have denials right here from different companies that wouldn't do it because of the background charge. I had a possible felony at the time. So for almost 4 years now, I've been denied. And in the last month, 2 months, I just got a job there with the Great Lakes Security. So I worked a couple times with them, and they have child support to take the money out of the check that just happened when I worked. I believe it was the last month when I had one last time there. But they're trying to get me in rotation in the schedule there. So I'm trying to get my after being taken the charge, now I'm able to, without nothing pending, I can probably do more. But up to that point, though, it's just impossible to pay, and the impossibility to pay, I invoke that in Michigan as defects.
What's the basis of the impossibility to pay?
I've had background checks where I couldn't pass for almost 4 years.
Anything else, Mr. Bregman?
I would just state that Mr. Howard could go down to the front of the court and ask for a referee hearing to have those child support amounts adjusted based on his job or lack of job or not being able to get a job. And until he does that, it's impossible for Mr. Basquez to do anything but process the order that's in place. So Mr. Howard could go down to the front of the court and go through the procedure, but until that happens, we are dealing with an order that is in place and enforcing the order that's in place.
I have children I look after every day. Like
Say that again?
outside of this coming to court, because I come here probably twice a month for the last 3 years. And like, I'm really trying to be outside of it so I can maintain what I'm doing at home.
We gotta pay your child
Yeah.
support, and then you don't have to come before. It's very simple. I have thousands of people that pay their child support and don't come to my court. All right, so it's finding of the court that Mr. Howard is guilty of failure to pay child support. He has an arrearage in excess of, as of today's date, $8,148.31. He has a de minimis charge of $151. I don't find the fact that he had a felony charge as a good enough reason that he can't pay child support, because I have tons of felons on probation who hold full-time jobs. I'm sorry, Mr. Howard, a lot of the information you provided does not apply to the civil court system. You're using language from the probate court that do not apply. So I do find that you're guilty of failure to pay child support. Sentence of the court was served 14 days in the Lenawee County Jail. You can be released upon the payment of $2,000.
This case shows how sovereign citizen language doesn't fail loudly. It fails quietly through missed procedure. The court never needed to argue philosophy. It enforced structure. Child support orders don't depend on contracts, trusts, or consent theories. They depend on jurisdiction and compliance. The key decision wasn't the sentence. It was earlier, choosing arguments that don't trigger relief mechanisms. The court explained the correct path: modification hearings, adjustment requests, documented inability to pay. Those are doors the system recognizes. None were used. Instead, time was spent challenging identity, jurisdiction, and imagined estates. Each of those choices delayed action while arrears grew. Civil courts measure patterns, not beliefs. 3 years of non-payment without formal modification doesn't read as confusion, it reads as disregard. When the judge compares this defendant to others with felony records who still work, that's not moral judgment. It's a credibility comparison. The court is signaling that barriers alone don't excuse noncompliance, process does. The final outcome isn't about punishment, it's leverage. Jail here isn't about retribution, it's enforcement pressure tied to payment. That's how civil authority works, not to debate theory, but to compel compliance. This is the real risk of sovereign citizen thinking in family court. Not that it's mocked, but that it's ignored. And while it's ignored, obligations continue accumulating, options quietly disappear, and the system keeps moving forward without you.